Hello, everyone. Welcome to another live stream session with ImmigrationQuestion.com, where we just dissect the latest immigration trends and policies with the top professionals in the field. We're thrilled to have you here with us today as we tackle an important topic that affects thousands of professionals in the U.S. Adjusting status from a work visa to a green card. What are your options? My name is Chanel Ford, and I'll be your host for today's session. Take a minute to think about this. You've built a life in the US on a work visa. You've settled in, built a career, maybe even started a family. But in the back of your mind, there's always a ticking clock. Visa renewals, sponsorship concerns, the uncertainty of staying long term. The dream of permanent residency feels out of reach. So, how do you make the transition? That's exactly what we're going to discuss today. To help us navigate this journey, we're joined by a true professional in the field. Our guest is an immigration attorney with over 20 years of experience. Her expertise spans in both non-immigrant and immigrant visas, making her an invaluable guide for professionals looking to transition from temporary to permanent residency. With a background in federal, civil, criminal, and appellate law, as well as government service and private practice, she brings a wealth of knowledge to the table. Owning her background, she understands firsthand the critical role immigration law plays in the US economy. A global citizen, a digital nomad, she provides strategic, personalized immigration solutions to clients worldwide. Everyone, welcome with me, attorney Mia Giacomazzi. Welcome to the show, Mia. How are you?
Thanks, Chanel. What a wonderful introduction. And I have to say, the intro music got me a little excited about this topic today. Thanks so much for having me.
Lovely to have you here. To our audience watching on various platforms, as always, it's about to get exciting. Grab your notepads and pens and let's jump right in. First, attorney Mia. Many of our viewers today are wondering, what are the basic eligibility criteria for adjusting from a work visa to a green card?
Well, that is a question that I get on a daily basis of, okay, I'm here, I've got my work visa, and various kinds of work visas. What are my opportunities to transition from a temporary work visa to the permanent immigrant visa, the green card? Um, to help us sort of go through all of the different options for people at home who might be watching in the various platforms, I have prepared a slideshow that I kind of wanted to go through just to sort of also give us a little visual representation. So I wanted to share my screen
Please
and
do.
see.
Knowledge is power.
That's right. So I'm going to share my screen here and get the presentation going. Um, Okay, there it is. So this is just our topic, the work visa to the green card, and what are our options? Before we get started, I do want to do a disclaimer. I would not be an attorney if I didn't give my little disclaimers first, that this is for informational purposes only. Every case is different. The laws are changing. That what may be very specific to one person is very different for another person, and we are going to exclusively focus the conversation today on employment-based eligibility to adjust from your work visa to a green card or an immigrant visa. So we won't be discussing other potential pathways, including, for example, family or investment opportunities. And a completely separate topic would be, okay, I am, on an H-1B or an H-2B or an L-1, and I want to get a green card. That's what we'll be discussing. But in a separate topic would be, well, what happens to my family during this process? And can they come along with me? And what if they're in the US? And what if they're outside the US and all that? And for purposes of just focusing today, we won't be discussing that. But those are some really exciting topics to also discuss for perhaps future reference. So, um, it's important to know, well, what are the employment-based immigrant visa? Someone says, okay, I want an immigrant visa. I want a green card, permanent residency. These are all the same concepts, different words for the same concept. So it's first best to really go back to, well, what are the various categories? There are different categories, but for purposes of today, we'll look and say, okay, there's EB or employment based one, and these are the priority workers. There's EB2, which are for professionals, either with advanced degrees or persons of exceptional ability. EB3, which are skilled workers, professionals, unskilled workers. This is a very wide category, and actually, it has the most applicants each year in the EB3 category. Then there's religious workers, and then the EB5 are actually for your investment. So we're going to be focusing on the EB1, 2, and 3 today. And some of these are going to be your employer sponsored visas, and that is EB3 and EB2. And then some of these, the visa holder is determined to be of such a priority or has a national interest that they can sponsor themselves without needing an employer. And we're going to talk about both of those, the self-sponsoring or self-petitioning types of visas, as well as the employer-sponsored. The first thing I like to do when I'm evaluating whether someone fits into the category or fits into the work visa to the green card is, before we even talk about how to get there, I like to start at the end first to say, well, are you even eligible for a green card? Are you eligible to adjust status? Because if you're not, then, it's a long process. It's a complex process. I enjoy it. I love it. It's good for everyone, the worker, the business, the economy. But there's no point in walking the path if at the end you won't be eligible. So there are specific criteria for ultimately being able to apply for the permanent resident or the immigrant visa while you're in the US. First, you must have actually entered the US lawfully, so with inspection. So if you are not lawfully present in the United States, you're not eligible for an immigrant visa or a green card while you're in the US. But since this topic is how do I transfer from my work visa to the green card, we're expecting that everyone is lawful. But the second, you have to continue to maintain your immigrant visa the entire time. And so sometimes there becomes issues if you come in, you have an H-1B, you've been here for a long time, and then you lose your job. And what happens then? You must be in a valid non-immigrant visa status. So you must have entered, but then at the time of applying, you must have an actual valid status at the time of application. And then your priority date must become current. And again, the priority date is it's a very specific thing in immigration law that you can have a complete webinar on how to read the priority dates and when do they become current and this and that. But we're going to talk about that when we talk about timelines in a little bit as well. And then, of course, there's lots and lots of questions as it relates to eligibility, and that covers immigration issues, criminal issues, unauthorized employment, and it even covers things like, your medical history. So, and so we go through and evaluate for all those things. The most common pathway to go from your work visa to the immigrant visa is through your employer-sponsored immigrant visa. So this is where you really have you have a job offer from an employer. So this means you have to have a U.S. employer who is willing to sponsor you for this visa. And then it is really a 3-step process. The first step being that you apply for a PERM or permanent labor certification with the US Department of Labor. And then once you apply for the PERM and get that approved, then you go to USCIS. So the PERM is a process where the US Department of Labor wants to test the labor market. And at the end of it, it will certify that there are no US workers who are willing, qualified, and able to fill the position that your employer is sponsoring you for. So what's important about that, and what I like to emphasize about the PERM process, is when people when employers are worried to say, like, oh, what if this is taking away US jobs or something like that, the response is, well, it's built into the procedure that we do these robust recruitment, and we do all of this very detailed process required by the US Department of Labor to ensure that that all U.S. workers have been given the opportunity to apply and to be evaluated on whether they're qualified, willing, and able for the position. And if not, you continue with your sponsorship. Once the USDOL certifies it, then it goes to the USCIS. And the employer goes to USCIS and says, okay, Department of Labor has checked off that there are no US workers who are willing, able, and qualified for this job. Will you please reserve an immigrant visa for my sponsored employee? And then if USCIS says yes, then the final step is that the employee can now apply to USCIS and say, okay, you have reserved this immigrant visa for me, but now I have to prove that I'm qualified. And that's when we go back to the eligibility of, okay, I enter the US lawfully. I am currently in a lawful status. And here's all of my immigration history and my travel history and where I've lived and all of that. And I'm qualified. And at the end of all of that, that's when you would be approved for your immigrant visa. And okay, now you're a permanent resident. And as mentioned, this is the most common pathway. And these are for the EB3s and EB2s. Any questions on that? I know I'm talking a lot and I wanted to have
No, that
I'm
actually
throwing all kinds of information at you, but do you
this I believe is so informational. Like, I hope everyone that's watching truly understands, like, these are some really key differences. Understanding, like, these letters when you go and you're filling out form make all the difference in the world. So understanding the difference between, like, the EBs and the H1Bs, I think are really, really significant. So thank you for going into that detail.
Sure. And here's a timeline. So if you're going through an employer-sponsored visa, listen, green cards, you can watch the news and that's like what people are talking about all the time right now is, it is an important benefit of that the USCIS is providing to someone is permanent residency up to 5 years. And then it's a pathway to citizenship that if you maintain residency after, 5 years, then you're eligible to apply for naturalization. So it is a difficult process. They want to make sure through that perm process that you're not, that they're testing the labor market and ensuring that, the position has been fully vetted, and that the DOL has to certify that that this position won't be taking any US jobs. Okay, so that right now the processing times are taking a little longer on the perm, so it may take about a year and a half. But the DOL has recently switched its the system on which the perms are filed, and I expect that actually those processing times might be sped up because it is a more efficient system. And then after the perm is filed, again, you go to the USCIS, the employer goes to the USCIS and asks USCIS to reserve that immigrant visa for the sponsored person. That's the form I-140. That one is actually eligible for premium processing, so that can go relatively quick. It can go, you can do it in as quick as 15 days with the premium processing, or it'll take a couple of months. Then you have to wait for your priority date to become current. So we talked about the three steps of the process: the perm, and then the I-140, and then your adjustment of status filing. But there is this fourth kind of looming thing here, which is the priority date. So once the I-140 is approved, you can't just automatically file for your adjustment. There are some categories that can, if their priority date is current. But there are a lot of things affecting how long you have to wait for your priority date to become current. And as mentioned, we could do an entire webinar on that. But some of the categories, and particularly for some of the countries, are very retrogressed, meaning it could take several years. And some of them, it could be an immediate filing, or it could be just a couple of months. So it really is a very specific question, depending on the time of year or the type of visa that you have applied for. So that's why there's several question marks there. And then you file your adjustment. So this is kind of the timeline. And again, the processing times are current to today, but they're always changing, and it depends on many factors related to what service center it is, what your category is, where your country of origin is, lots of things. So I guess that kind of completes my conversation as it relates to the self-sponsor, to the employer-sponsored. Do you have any questions, comments, or would you like me to move on to the self-sponsored?
No, you answered the second question I had, because I was going to ask like the key differences. So you broke that down beautifully. So you can definitely move on to the next fit for sure.
Right. So that with the self-sponsored immigrant visas, I mean, the main difference is there's no employer needed. You get to sponsor yourself. But to be able to do that, you have this higher burden of proof. You have to, not everyone can sponsor themselves. It's really the ones who have this extraordinary ability or who have been determined to be eligible for what's called this national interest waiver. And I'm going to give some sort of examples, to really fall under the EB1 category. We're talking about professors, national, international recognition in your field, getting prizes. We're talking about in well-known international prizes, publications, media coverage, judging other people's work. These are your very special people who probably would be on, let's say, an O1 as their non-immigrant visa, who are then transitioning over to an EB1. The EB2 has two categories. There's just your regular EB2s, who have advanced degrees or exceptional ability. And then there are people who have advanced degrees like master's, bachelor's plus a certain amount of experience, or your PhD people who also have a plus factor, who meet a specific number of criteria that are specifically listed within the regulations. And again, these are just not your average. Like if you have a PhD, that's great, but you're not going to be a national interest waiver candidate unless you also are able to establish these plus factors. And it's about work with substantial merit and national importance. Evidence showing the U.S. would benefit from waiving the job offer requirement. Again, publications, awards, media coverage. There's a list of them, and if you think you might qualify, then definitely you should see, this is something where you're not going to do it on your own. You should definitely see a professional to do it. So we're talking about scientists, researchers, particularly in fields of national interest, so like robotics, AI, all the engineering, green technology, all of these things that are really going to be very important to the US and the US economy, infrastructure, those sorts of things. And healthcare professionals also fall under this, particularly serving underserved communities, improving them, building them up, that sort of a thing. And the self-sponsored timeline, the what self sponsorship does is it allows you to jump over the perm. So you don't have to do the perm anymore. You just go straight to the I-140 and then you wait for your priority date and then you get your AOS filing, your adjustment of status filing. So it's a longer preparation of the application because it's just so much more detailed with how you actually qualify. But then you don't have to do the perm. You go straight to your I-140, and then the priority dates will be will take less time because there's just such fewer people who are actually going to be qualified for these positions that there's more visas available at a quicker timeline. Um, so what are common obstacles to actually obtaining the immigrant visas? There's delays in processing, there's delays in the perm, there's the backlogs, especially for people like EB3s and EB2s for people in India and China that could go 10s, 20 years. RFEs, changing laws. We're seeing the laws for these things change, on a daily basis. And again, going back to your introduction, the question that is in everyone's, mind is, I'm here, but I have to continue to maintain my status. And you have to continue to maintain your status until you get your immigrant visa. So you have to continue to maintain the status until you can actually apply for the adjustment. So that's something to continue to consider. Whoops, I'm clicking the wrong button there. So the best practices for me is to start early. Don't wait until your visa is expiring. Work with an experienced attorney. And maintain lawful status at all times. And another thing that I could say is, like, for example, well, coming over here, I say, strategic planning makes a big difference. So if someone comes to me and says, I'm looking for an EB2, NIW, or I want to see, I'm an Indian national, I've got this I-140, but it's going to take a long time. My priority date is just so far away. How can I jump into an EB1 category? Well, it might be that you can work to improve your eligibility by writing books, getting published, doing something to put yourself into the higher categories that will allow you to become a self petitioner. So we look kind of forward, and there are people who work with immigrants to help them improve their ability or their profile to get into those self petitioning or to have successful self petitions. So yeah, I mean, I guess that was the presentation. I know that we're getting close to times, and perhaps we'd like to take some questions.
Definitely. To our amazing audience, thank you for joining us. If you're tuning in just now, we have attorney Giacomazi with us, a seasoned immigration attorney who's contributed significantly to today's topic. Before we jump into taking questions, I'd love to ask you one thing.
Yeah.
For a platform that seeks to aid immigration journey of every documented and undocumented immigrant by connecting them with seasoned immigration attorneys like yourself, what do you think of immigrationquestion.com and what we're doing for the immigration community?
I think it's great. I mean, a lot of people have immigration questions and they just don't know where to start in terms of getting answers to their questions, and getting help and getting assistance. And so to have this platform where people can go, and it's easy to find immigrationquestion.com. I have a question about immigration. I'm going to go to immigrationquestion.com, and they're going to connect me to an expert. And I really think that it's a great resource for people to begin, and it's a great resource for attorneys to be connected with people who need assistance and who need help, and we're happy to help them. That's what we're here for.
Definitely. Thank you so much. To our viewers, feel free to ask a question any language of your choice, and you can get it answered for free at immigrationquestion.com today. Register today. We're going to jump into our live question and answer portion now. Our first question is from Priya. My employer is doing perm for me, but it's taking long. My work visa is close to expiring and my perm may not be ready. Can I stay in the US while waiting?
So the answer is no. So remember that there are multiple steps here to being able to apply for the green card. The perm is only step one. And you're right, Priya. Unfortunately, perms are taking a long time these days. But having the perm be certified still does not allow you to adjust status. You still have to go through the employer asking the permission from USCIS to reserve the visa or the I-140. Then your priority date has to be current, and then you can apply for the adjustment. And at the time you apply for the adjustment, you have to be in a valid status. So if your work visa is getting ready to expire now, you're kind of far away from being able to do the adjustment, because you still have, you need the perm, you need the I-140, you need your priorities. So date current. So you will need to be able to extend your current visa, or you'll have to leave and then return back to your home country and then come back in on a new work visa. If you're on H-1B, I mean, the good news is so long as the perm was filed before your year 5 on your H-1B, then you can continue to extend your H-1B while your perm is going, and then once your I-140 is approved, you can continue to stay in H-1B status. If you're on a different type of visa, though, you will have to either switch to a new work visa type, or you have to go back home and come back in on another work visa. The great thing about, and we didn't touch upon this, is that if you are not in the US and your perm that your employer sponsored you for is approved, they can still do the I-140 for you. And then instead of adjusting, you can actually apply for your immigrant visa in your home country. And that's through your consular processing. And then once you get that, then you can come in directly on the green card. So technically speaking, you can get an employer sponsored immigrant visa even if you're not in the United States and never been to the US. And it's not through adjustment of status, but through consular processing. So it doesn't, even if your work visa expires and you have to go home, the process doesn't end. They're two separate things: the short-term non-immigrant visa and then your longer term one. And I do them, for my clients, it's about doing them both in parallel and continuing to ensure, and then adjusting your strategies based on where your temporary visa is in relation to the long-term visa.
Thank you. I just learned so much during that answer. Kareem, I am on an L1 visa and my wife is on an L2 with work authorization. If I switch to green card process, will my spouse be able to work as well as we wait for approval?
Okay, so this is definitely the question that I sort of discussed at the beginning, which was, we're not talking about what happens with the family because this is a whole nother discussion, right? But the short-term answer is, okay, you can't, if you switch to green card process and you get your approved I-140, and then you get to the point of when you file for the adjustment of status, you can include your spouse in that. And then you can file for your employment authorization documents. And then once those are approved, and while your 485 or your adjustment is pending, you will be able to work.
Thank you so much. And let's see, do we have time for one more? All right, there we go. Camilla, I filed my I-485 for a green card through my employer. May I travel internationally as I'm waiting?
Well, the answer is it depends. So when you file an I-485, what that does is it is asking for you to adjust status from your non-immigrant visa to your immigrant visa, okay? If your immigrant visa expires while you're waiting for the 485 to be in process, which may take a year or more, okay? It allows you to stay in the US. And in fact, you can't leave unless you apply for advanced parole, an I-131, and you have that approved. And so if we always, unless you have a different type of visa, which allows you to travel internationally and it's valid. So, for example, if you have an H-1B or an L-1 and you apply for a 485, but your H-1 is still valid, then you can travel back and forth on your H-1 visa. If, however, your 485 is pending and your visa that you applied for expires, then you can only travel internationally with an approved advanced parole document that is issued by USCIS. So so the answer is maybe if you also applied for the I-131, but you can apply for that anytime. So even if you didn't apply for that at the time you applied for the 485, you can separately submit that application.
Thank you. Perfect. I think that was the last question. Okay, good. This has been such an interesting conversation. Thank you so much for joining us today. I've
My
learned so
pleasure.
much. I hope the audience has learned so much. We hope that this webinar has helped you. If you have any questions or if you want to learn anything else, visit immigrationquestion.com so that we can connect you with an immigration attorney who can guide you through your journey, such as Attorney Mia here today. If you've missed any part of this session or want to listen again, this recording will be available on Spotify and other platforms of various that you like to listen to. Just search for Borderless Talk by immigrationquestion.com. Join us next week for another great session on employment-based immigration. Chanel, and I'll see you next time. Thank you so much, Mia, for joining us today.
Thanks, Chanel.